Hi everyone and welcome to week 9. Week 9 already. We're just getting through this so fast. So today we're going to talk about mental health law and offending. And this is really topical all the time when you think about some of the things that have happened in Australia in the last few years, such as the Live Cafe siege, such as the fellow in Melbourne driving cars into crowds, which happened a couple of times. And just in the last couple of weeks in Brisbane at Mount Gravatt, we had the shooting of a fellow up there who attacked a police officer with a knife. It's now coming out that he had a known mental health issue, and so the police are being criticised yet again. But it is a very, very topical subject. So let's get into it for today. So this is what we're going to cover today. We're going to talk about the relationship between mental health and crime, or mental illness and crime, because it is really, really complex. There is no causational effect here. Just because someone's got a mental illness does not mean they're going to commit a crime. There's really a lot of confounding factors. And I know that you all know what those things are now from doing criminology with my ESSA. So we're going to talk about that today. And what are the problems with understanding this relationship between mental illness and crime? We're going to talk about a case study, a really interesting case study, and then we'll look at that more in the tutorial. And we're going to talk about competency issues. What does that mean? Well, it's the competency or the fitness of the person to stand trial. Are there things that they need to be able to understand, both in relation to what they've been charged with and the process that goes on in the court? Or should it be postponed until they've had some treatment? What is criminal responsibility? Diminished responsibility? You will have covered a lot of this in other courses, so we'll talk about that today. And the insanity defence. Is it really as straightforward and common as what we are led to believe? But when we talk about the insanity defence, we're interested in the level of awareness or any mental health problems at the time that the crime was committed, and then when the person is standing trial. And then we're going to talk about some Queensland court statistics in relation to the mental health court. So by the end of this week, you should be able to understand the relationship between mental health and crime, understand the factors in determining competency to stand trial, identify what criminal responsibility is, and understand the insanity defence. Is there a link between mental health problems and crime? Well, there is a perception in society that the mentally ill are dangerous. The media would have us believe that those with mental health problems are going to commit a crime. There's a short YouTube video there. It is actually a clip from a film with Leonardo DiCaprio set in a mental health prison that just goes to show how the media presents mentally ill people. So go and watch that and come back. Okay, so as you can see with that, there is a relationship, but we need to look at the confounding factors. The number of mentally ill people in the criminal justice system is in part due to the capacity of the system to be able to offer facilities and treatment. So in the 1980s, we started to offer people more care in the community rather than being institutionalised. We can see that there are a large number of people in prison with mental health issues, but are they committing crime due to those issues, or has being incarcerated led to those issues? Shaw, in 1999 with his colleagues, conducted a study and found that 44% of, which is nearly half, had a mental disorder in their lifetime. We're looking at offenders here. But only 14% had symptoms of mental illness at the time of the offence. So I don't know, but do you think that those are really, really high numbers? Do you know what the level of mental health issues is in society? Now, that's probably a really loaded question at the moment with everything that's going on with COVID, because we know that mental health issues are going through the ceiling as a result of people being locked up at home. We also know that domestic violence cases are rising substantially due to people being under financial strain, as well as simply just having to work from home. But if we were to go and ask people if they've ever had a mental health issue in the general population, what do you reckon it would be? Well, about 45% before COVID would answer that yes, at some time in their life they have had a mental health issue. If you ask people if they currently had a mental illness, the percentage would be around 1 in 5, so about 20%. So, and of course, this is all pre-COVID. So, adding COVID into the situation would mean that the figures would probably be a bit higher. But when you compare the statistics in the general population to these offenders, it's not really high at all. It's pretty normal across society. And if you look at this another way, with the second figure there, you have to remember it's stating that 86% did not have an illness at the time of the killing. So do you find that more scary than thinking about 14% that did have symptoms at the time of the offence? But what is less researched is what is it that stops people from committing crime? Why don't all people with a mental illness kill other people? So Hodgins in 1997 identified these three types of evidence as supporting the association. There are higher levels of mental illness in convicted offenders. Whether they're mentally ill at the time they committed the crime is something different, but they do have higher levels of mental illness. Studies that compare criminality in those with a mental disorder on release into the community with members of the same community with no mental illness. So they compared criminality in those with a mental illness when they were released into the community, and this is how they were getting their figures. And finally, long-term studies of people born in a particular period show that those who develop a mental illness also tend to have higher levels of criminality. This is a longitudinal study, so they're following individuals over a really, really long period of time. Now, you have to think about people born in a particular period. People born during periods of war, where they might be born into a life where there are restrictions, they're going to have different ways of looking at the world than those of us who have been born into periods of prosperity. So what are these confounding variables? So lower SES, this is suggesting that people who have got a mental illness probably don't have occupations, so therefore they may live in an area with a low SES. And therefore they may be tending to live in communities that are more violent anyway. So there is a social drift for them to these types of communities. This needs to be taken into account before we can definitively say there is a relationship between mental health and crime. The effects of medications. So some medications that are taken by people with a mental illness may actually increase their aggression. And at the beginning, when someone is diagnosed and put onto medications, they have to get the levels of the medications right. While their bodies are getting used to the medications and while doctors are trying to level them out, they can cause increased aggression during that period. Misattribution of behaviours. The general public are more likely to ring the police if they see someone who is behaving a little odd or erratic. So the general public could misattribute their behaviour to them being dangerous when actually they're just a little bit odd or a little bit different. They may well have a mental health problem, but they're not being violent or committing crime. They could be having hallucinations, but we as the general public draw attention to them and label them as criminals. And overlapping definitions. So violence or aggression can also be a symptom of antisocial personality disorder. So the violence can actually be a symptom of something that's quite treatable and not be so much caused by the mental illness. So there's lots of problems when we're trying to understand this relationship. First of all, methodological problems with sampling, and you all understand now about sampling. So who is our sample or our respondents here? Are we only looking at those with a mental problem, mental illness who have not committed a crime? Are we only looking at those with a mental illness who have committed a crime? Social factors. There is a lack of services for these people. Deinstitutionalisation. So people who are in prison not receiving the care that they need while they're there. And as I said before, increased detection by police. So public becoming more aware and more wary of people and causing the police to get involved when really they're not committing any crime. And comorbidity with substance abuse, the combination of drugs and mental health issues is particularly criminogenic. And drugs and alcohol are quite often used as self-medication to lessen the symptoms. So obviously these people are doing this themselves, thinking that they are going to lessen the symptoms that they're feeling by taking drugs and alcohol. So what are the mental, personality and intellectual concerns in court? So there's two main things that we need to establish. The person's current state of mental health. So what is their state right now as they're about to start going through the court process of their mental health? Are they going to be able to withstand the court process? And then we also need to look at the state of their mental health at the time they committed the offence. So they might have had treatment since they were arrested and be fine now, but what was their mental state at the time they committed the offence? All right, we're going to look at our case study today. This is Ralph Tortorici, who was born in 1968 and tragically took his own life in 1999. He was quite a normal child, but became more aggressive as a teenager. He was diagnosed with paranoid schizophrenia in adolescence and believed that the police were out to get him and that the government was controlling his behaviour. Now, how the government was controlling his behaviour was due to a problem that he'd had as a small child, where he'd had a series of operations to correct a defective urethra. And he became convinced during the last of these operations that the government had planted a tracking device in his body, specifically in his penis. The microchip was telling him to molest young girls. So he got treatment for all of this. He went to university as the behaviour settled down, and would you believe he started to study psychology. At age 24, he went to the University Medical Centre and claimed to them that there was this microchip implanted in his penis, and he was referred by a psychiatrist to a psychiatric centre. He engaged in this siege. During the siege, another couple of students were injured when they tried to overpower him. He made some very, very specific types of demands. He wanted Bill Clinton to come, who was the president at the time, to come to the university to speak to him, amongst other things. He tried to use drugs himself to deal with his paranoia, because that coincided or gave him or led to extreme depression, fearfulness and anxiety, and he also smoked crack cocaine. So he was arrested and charged with attempted kidnapping and other charges, as you can see there. And there's a video there for you to watch. The original one that I used for quite a long time has now been removed from YouTube. So this is a different one, but it gives you a really great understanding of Ralph and his case. So go off and watch that and then come back. Okay, so initially when Ralph went before the court, he was found incompetent to stand trial. He was given a diagnosis of delusional disorder and ruled not competent to stand trial, as he needed to be able to assist his defence and understand the nature of the charges against him. So he was admitted to a psychiatric hospital where he refused to take all medications and was noted by the staff to be delusional and aggressive, being placed into a straitjacket on several occasions. Then a psychiatrist declared that he was no longer an incapacitated person, but was now calm, collected and cooperative with no delusional beliefs. On the same day that the doctor declared that, a nurse wrote in his file that he was responding to hallucinations frequently talked to himself and that his behaviour was disruptive. So he went to court. The defence and the prosecution ignored that he was not fit to stand trial, indicated that they were ready to proceed, and the judge agreed. It was noted that the threshold for competency was so low that really he only needed to know the difference between a judge and a grapefruit, which he obviously knew. So the prosecution argued that as he knew that the judge was not a grapefruit, he was competent to stand trial. Okay, now I know that you should have watched the YouTube clip by now, so you will fully understand that Ralph was never ever at any time competent to stand trial. So what does competency to stand trial actually mean? And these are going to vary slightly across different jurisdictions. They must be sufficiently able to follow the court proceedings. So they need to understand what's going on around them. They need to understand that jurors may be challenged. And we'll talk a little bit about this when we get to week 11, about how jurors are selected and how that's important. They need to be able to comprehend the details of the evidence. So what is the evidence against them? They need to be able to understand that. They need to be able to understand the implications and the meanings of the charges, understand what they've been charged with. And they need to have the ability to instruct their lawyers effectively. And they need to be rational instructions. Nothing silly like let's all go and shoot the prosecution. They need to be able to instruct their lawyers effectively. So if declared unfit, the hearing is held to determine the likelihood that they committed the crime. If unlikely or disproved, then they're discharged. Don't forget, likelihood does not always equate to guilt. Okay, so they need to be competent to stand trial. What about in Queensland? Well, in Queensland, under the Mental Health Act, they must be fit to plead at their trial and to instruct counsel and endure the trial. Because don't forget, some trials can go on for a really, really long time. And this needs to happen with serious adverse consequences to their mental condition unlikely. So we must not be able to see any adverse consequences in relation to their mental health. Who makes these decisions? Well, we have a Queensland Mental Health Court, which is constituted by a Supreme Court judge with 2 psychiatrists assisting, but overall and ultimately the decision is made by the judge. The judge determines whether the person is fit to stand trial to start with. If they are unfit, whether this is likely to be permanent. In other words, can they be admitted to a psychiatric institution and treated to a point where they will now be fit to stand trial for what they've done? Do they have criminal responsibility for the crime at the time that it was committed? So were they of sound mind at the time, or were they of unsound mind, or is there diminished responsibility? So these are all things that we are going to talk about. So if they are considered to be unfit to stand trial, the Mental Health Court can remove them from the court into the mental health system. So they move from the justice system to the mental health system. The court can make a forensic order to detain them for treatment or care, and how long that's going to be for. They can also be treated in the community, but that really depends on the severity of the charge and how dangerous they're seen to be to the community. Criminal proceedings can be discontinued if they're permanently unfit. So if they are seen to be unfit to stand trial, this then has to be decided whether this is going to be permanent or if it's only going to be temporary. If temporary, then regular reviews will occur and they'll end up going back to the criminal justice system. If it's considered to be permanent, usually they will end up in a mental health institution where they will have to live until somebody decides that perhaps they're not a danger to the community anymore, and that would have to go back before a court. But otherwise, as soon as they're considered to be competent to stand trial, they will have to go back before the court and answer to what they've been charged with. Okay, that's the end of part one. Part two is quite short, but we're going to discuss more around the rules of being able to take criminal responsibility, having diminished responsibility, and using the insanity defence.